you begin again, Mr. Fenwick, Lord Justice Arnold, can you hear us?
I can, thank you.
Good. Just making sure. Thank you, Mr. Fenwick.
Thank you, Maranello. Before I just conclude my submissions in relation to fiduciary duty and duty of good faith, I just want to make two things clear, which I'm sure are very much present to the court. The first is that it's no part of my case today to show that I will win on any of these arguments at trial, whether as to the construction of the settlement agreement, the sharp practice rule, nor as to the existence of the conspiracy. What I have to show is that the case is not so plainly bad that it remains reasonably arguable in each respect which I need. And of course, the process of disclosure and witness statements and testing at trial may mean that, for example, the difference between what Mr. Walmsley, a solicitor, put in the first page of his spring law letter and what he said to the court will be tested and court will reach a view.
We understand, Mr. Fenwick, that we're dealing with a strikeout.
Absolutely. And secondly, that when I'm dealing with this next set of claims, the breach of fiduciary duty, breach of the duty of good faith, are all unlawful acts pursuant to the conspiracy and exist to that extent. If there were no conspiracy, then the question of whether they were settled by the settlement agreement is a very different matter, as we made clear to the judge. So this is all in the context of whether the judge was right, because what he did was not simply to say settlement agreement covers all, no sharp practice. He then went on to make these very large numbers of findings about almost every aspect of the case. And I just want to pick up to show that there is a fully arguable case in relation to duties owed of a fiduciary character or good faith. Can we just pick up again to remind ourselves in tab 3 of the supplemental bundle, the letter at page 5 of the 21st of May.
Supplemental bundle, tab 5.
Tab 3,
Tab
page
3,
5.
page 5. Thank you.
You'll recognise the letter that I sent.
Yes.
And of course, this was the letter in which there was set out the terms of the risk transfer agreement with RM, which was being under discussion for abandonment in favour of a similar deal with Bonhams. Those terms having been said in the letter, in terms have been agreed, no contract, but they've been agreed terms. And then we go to the letter at page 9 by email of the 22nd of May. The confirmation, albeit subject to contract, then the Women Group will make the funds available for the acquisition. Bonhams will sell them by public auction in September 2014, substantially on the terms set out. So that's what they were representing. And the terms which they required was, first of all, confirmation, which they got. Secondly, as we already know, exclusive worldwide rights for Lumen and Bonhams. No discussions with anybody else. So, as from this moment, when it was accepted and confirmed by MRL that it would cut off negotiations with RM, would give Lumen and Bonhams exclusive worldwide rights, and not discuss it with anybody else. Bonhams were in a position in which, notwithstanding the fact that no express contract had been signed, whether of agency or of purchase, Bonhams had taken a right, exclusive worldwide rights, and effectively a dump RM. And in my submission, it is entirely reasonably arguable that having done that and continued with it until the agreement was signed on the 30th of June, the commercial agreement, Bonhams owed duties of a fiduciary character to act fairly towards MRL. During that period of time, they were considering and preparing the cars, was getting ready for them to acquire. My clients were expecting Bonhams to be acting in its interests in deciding how to deal with it. They wouldn't have been buying and dealing with them unless that had been agreed. And to say as a learned judge, say, well, really, until the 30th of June, there was no contract. This wasn't worth the paper it was written on. We could have talked to RM, we could have sold it. They didn't have any exclusive worldwide rights. Bonhams didn't owe them any arguable duties of a fiduciary nature. Is in my submission entirely contrary to the authorities. And what we say was that the consideration for us doing all of that was that they would enter into a transaction on substantially the same terms. And
that's an agreement to agree, isn't it?
It is an agreement to agree, but if you just have an agreement to agree in a vacuum, that of course doesn't provide any duties. But when you have a transaction which is to be completed and everybody is working towards preparing this collection for sale, and they are discussing things, by the 30th of June, the cars were in the Bonhams showroom, the brochure had been printed for the sale at Quail Lodge, all sorts of preparatory steps had been taken. And to say that during the entirety of that period, Bonhams owed no duty at all.
Well, it'd be very odd if they did owe a duty, wouldn't it, before anyone has... It seems to me all that's being agreed here, to the extent there was any agreement, is that your clients will not deal with anybody else until the transaction has been finalised or presumably otherwise gone away.
Yes, that's all being agreed at this stage. But from then until the 30th of June, when the agreement was signed, Bonhams continued to act, for all intents and purposes, as if it was a done deal, and they were continuing to prepare.
Well, that sort of brings you into the territory of anticipated contracts which do not materialise, or something like that. But I've never seen it suggested that that gives rise to a fiduciary duty.
Well, you can have effectively both parts of the case, whether they were buying and selling for our joint purpose, or whether they were selling purely as agents. They were undertaking a duty as our agents to act in good faith. Now, the fact that the actual...
But there was no agency had been agreed yet.
Sorry?
No agency had been agreed. I mean, the agency was dependent, wasn't it, upon the Lohomij Group making funds available, and that at the moment was subject to contract.
That at this stage was subject to contract, but the Lohomij Group made the funds available and the transaction completed on the 29th of May. The fact that they didn't enter into the formal contract, the commercial agreement, until the 30th of June, doesn't mean to say that they did those duties as agent during that period, when throughout the period they were effectively all discussing and advising and working out how to sell the cars. They were talking about Goodwood, talking about all these things, and my clients were entitled to repose trust and confidence in them, that from the moment they said, this is what we will do, they would at least act in good faith, and we would say that they also would owe us a duty of loyalty, because whichever route the transaction took, whether by way of loan or whether by way of sale, they would need to protect our interests. And
well, doesn't that mean that in agreeing the 30th of June commercial agreements, they were inherently in a position of conflict? Because they were agreeing with a party to whom they owed a fiduciary duty.
No, you can owe fiduciary duties pursuant to an agency arrangement before you've entered into the formal agency agreement. Now, the fact you enter into a formal agency agreement and it has particular terms as to payment or commission doesn't mean that everything before that has no meaning and no significance. When it is done pursuant to a conspiracy, and if we are from this stage
sorry, that's circular, because the conspiracy you're alleging is a conspiracy to use unlawful means. So
yes.
You can't turn around and define the unlawful means, say it's unlawful means because it's a conspiracy.
I agree with that as so stated, of course. But in this case, what they're actually doing in the exchange of email and what happened, and there are numerous other interactions and emails between these parties, which the court has not seen. There are internal emails on both sides, which the other side hasn't seen. And in my submission, when one has this period of time, it is entirely plausible that the evidence will demonstrate that in the way they were acting and in the representations they were making, they were accepting a duty of fiduciary nature.
Presumably, if there was another document or email which you show demonstrates or supports the existence of a fiduciary duty, then no doubt you would have put that before the court.
If I had it yet. But document which I don't have, I mean, no doubt it said disparagingly of my client, he's a second-hand car dealer, quite smart second-hand cars, but second-hand car dealer no less. He's dealing with Bonham's Premier Auctioneer and Lohomij. And what is going to be relevant is what they were writing, what they were recording about what they were doing and what they had agreed in their conversation.
Hard to see how a document that didn't cross the line with you could give rise to a fiduciary duty in your favour, arising out of these negotiations.
No, but a document which didn't cross the line, which recorded conversations and discussions with my client, not recorded by my client. And my client's case is that throughout this period, they were working on the assumption that Bonhams were acting in their interest to sell the collection for the best possible price. That's their case. At the moment, apart from saying that's what we believe, I am met by, well, this wasn't a contract. It's not very clever. I have to accept that my client's conduct in terms of getting a binding contract or getting an agreement you're going to act as agent, isn't great. But that doesn't mean that there wasn't, in fact, discussions passing between them, right, which my client identifies as, throughout this period, we all worked on the basis we were going to sell them and everybody was going to get money out of it and reputation out of it.
I think I need to understand this. My understanding was that you were asserting that fiduciary duty arose out of the agreement, which can be divined from the exchange of emails that we've been looking at.
Yes.
Now, it seems that you're now suggesting that either in addition or instead, you could also get that fiduciary duty from conversations between the parties which were taking place at the same time. And I wasn't aware that that case was being run, and I wasn't aware, if so, what the gist of those conversations are said to have been, and where one finds them.
Well, what we have, I think, is that the evidence of Mr. Sullivan, that which is in short term. If we go to page 188
So at 188
of the supplemental bundle, that's tab 25.
So this is the meeting of the 21st of May.
21st of May, and he's here referring to the marketing plan, which had been sent earlier in the year. So you have to read this together with marketing plan. It's not in the bundle, but it's quoted here by Mr. Sullivan. Offer the entire collection by auction, protect by agreed reserves. Earliest opportunity after you exchange will research and prepare detailed cataloguing of the cars. Transfer all vehicles to the UK for storage. Preparing 8 key cars, etc. Direct mail. Over the page, full marketing resource will be brought to bear upon Goodwood sale. That's, first whole punch, bonds organised sales on its standard, trusted, well-tested UK terms and conditions business. Different exceptions. Then on 26, the marketing plan is critical as it was the basis for all future discussion of bonds about the auction of the cars. And then was the agreement in principle. At this stage, for the purpose of the strikeout, he's referring to that representation of the business plan what was going on. If we go on to page 191, paragraph 37, on 26th of May, travelled to Italy to meet with Mr. McLean in order to progress columns by home due diligence, finalise legal documentation. Work continued throughout. Then came the suggestion. All the way through, there is effectively an arrangement whereby bonhams are going to be acting in order to sell these at best price. It didn't mature into a contract of agency until the 30th of June in formal terms. But by the 30th of June, the cars were all in the Bonham showroom. They didn't get there by magic that night. They didn't get there without there being very considerable interaction between the parties, which will be revealed on disclosure. And my submission is that it is entirely plausible that when you look at that disclosure and see all the things that happened between the 22nd of May and the 30th of June, it will indeed demonstrate that by their conduct and by their activity, they were undertaking a duty of good faith to my client.
That
leads me to a question I wanted to ask, Mr. Fenwick.
Yes,
please assume, for the purpose of my question, that our conclusion is that bonds cannot avoid a fiduciary duty to your clients because a party negotiating an agreement cannot owe a fiduciary duty with its counterparty.
Yes.
So that's the premise. That then leads me to my question. As I understand it, you have an alternative case, which is you say, even if it's not a fiduciary duty, there's a, quote, duty of good faith.
Yes.
And I think you characterised it earlier as a duty to act fairly. can you explain to me what is the legal content of that duty and from whence does it arise?
The legal content of that duty is that from the moment when you ask MRL, you being Bonhams, ask MRL to limit itself by giving Bonhams exclusivity, then the legal content of the duty is not to act unfairly, knowingly against the interests of MRL. And there is no reason in my submission why such a duty cannot be owed in those circumstances.
But again, why is not the objection the same? Namely, that you're negotiating with the counterparty and therefore inherently your interests are reversed. Each side is trying to get the best of the deal. So how can there be room for a duty of good faith prior to execution of the deal? Of course, the position after signature of the contract may be different.
Well, if this was a position or a situation where the parties were, if you like, negotiating a deal in which neither party was going to be bound, that might well be the case, but that's not quite our position here, because we have a position where they have already made clear that they will take over the marketing and sale of these. The exact detail of that wasn't finalised, but it's not each side jockeying for position for the best deal. It's both sides agreeing that Bonhams will take on the marketing and sale of this in their joint interest. What was being worked out was the precise arrangements by which that would happen, the precise arrangements for the finance to be provided by Lohomij, and exactly what was going to happen about the commission. But the commission was broadly there. The agreement which was intended and was agreed to in principle and they were acting on until it changed was an agreement as set out in the RM term of the 21st of May. That is to say that there would be £6 million profit, there would be an interest rate, but essentially Bonhams, like RM, would act, and that was never an issue. So it's not the kind of question where there may never come into existence a contract. What was uncertain was exactly what the nature of the contractual arrangements might be. But the fact that there was going to be an arrangement was a sold pass from the 22nd of May, because there was no
That's
other
often
route.
the case, that you have an agreement in principle. There's no actual agreement and no duties until you have... it's classically where you have a label as subject to contract, which it seems to me you did here.
Well, it's slightly different when you end up with a tripartite agreement with Lohomij, but I agree that in general there isn't. But in the particular circumstances of this case, where you have this unique product and you're asking somebody to give up one contract in exchange for a representation that you are going to sell it for them on the same terms, then to say that there is no content of good faith, no obligation, you can say that, get them to give up the RM deal, give them exclusivity as a right, enforceable because it's said to be a contract, and then walk away with no obligations. In my submission, this court cannot say that there are no circumstances in which a duty can be owed in that, simply because they're negotiating. So you never owe any duty at all. I mean, if I just take another example, assume that a solicitor agrees in principle that he will act for a client. And they say, well, we'll have to look at the retainers, we'll have to look at how much money you've got, we'll have to look and agree terms of contract. But of course, you know, we will act, and in the meanwhile, you should prepare your papers and don't do this and do that, and we'll write a letter to the other side. But they haven't got their retainer there. Now, do they owe no duties? In my submission, they must owe duties, and they must owe duties to act in good faith in those circumstances. They may not have specific contractual obligations because they haven't entered into a retainer. But if they do things during that period, and if they put their client in a position where he is doing things at their request during that period, it must be open to the court to find that in those circumstances duties are owed. And solicitor can't simply say, well, that was that, I decided not to act after all. He may have no obligations, but it all depends on factual content. Until you have the factual content, you can't prejudge it. And that's why we say that this, as one of the unlawful means pleaded, is a plea which can be tested after disclosure and with evidence. And it may fail, and it may succeed, but it is not so obviously bad that it cannot succeed.
As far as relying on a fiduciary duty which arises from dealings and conversations other than those emails, it doesn't seem to me that that's a pleaded assertion. Pleading, I think 121 of the particulars of claim, 1211, is that the breach of fiduciary duty and or duty of good faith imposed on Bonham as a result of MRL entering into the exclusivity agreement and terminating negotiations with RM. There's no reference to any wider matters giving rise to a fiduciary duty.
No, I accept that, but whether or not that is the case, unless this court were to hold, holding the judge, that there is no possibility of any duties arising, then I have pleaded sufficient based on the agreement, and whether or not there were duties owed and what they were breached is a matter for trial.
Well, forgive me, it isn't a matter for trial. The judge is entitled to look at your pleading and not to allow the matter to continue for a fishing expedition to see whether this disclosure shows matters which will enable you to adduce a different basis for alleging a fiduciary duty. And arguing in this court without even applying for permission to amend your pleading, to rely on that, seems to me to be impermissible.
No, well, with respect, it's not, because what I'm saying is that anything which arises must arise out of that exchange of letters. Without the exchange of emails, there can be no content to any future actions. So it's that which we plead and which we rely on. What we say generally in relation of these is that the learned judge has effectively preempted the task of the trial judge by making his findings. Can I take you to paragraph 76 of my submissions, which is in Core Bundle 1, page 56. And this is dealing with the claims for breach of the fiduciary duties of good faith and dishonest assistance in them. And we draw attention to the fact that the judge appears to proceed on the erroneous assumption the defendant's evidence should be assumed as being correct. And then he comments on Ms. Wolf, who gave a statement for Lohomij as to the choice of venue. His comment, he sees no evidential basis for gainsaying that statement. Oh, that's saying that there was no involvement in the choice of venue, which is completely contrary to the evidence which my witnesses, MRL's witnesses, have put in their witness statement. And we say that the judge should have looked at all of this on the assumption that our case, as supported by the evidence and as pleaded, except not with things which are not pleaded, is correct, except where it can be shown to be fanciful. And the judge, all the way through, looks at documents and assumes that they're the only relevant documents for deciding what he has to decide. I'm going to move on to ground 4, which is relatively straightforward, because the learned judge accepted that, but for his finding that the settlement agreement barred a claim in conspiracy and that the sharp practice principle didn't apply, he would have let the claim in conspiracy go forward to trial. So if I'm wrong on the first ground of appeal, then of course I lose on ground 4, but if I succeed on the first ground of appeal, then the claiming conspiracy should go forward to trial as the court found. I'm going to move now to the claim against Bonhams and Butterfield, which is another example with respect of the learned judge prejudging.
Give me just sorry, to keep interrupting, but I just need to understand.
Yes.
I thought the reason the judge rejected the claiming conspiracy wasn't just the settlement agreement, was it? It's because he also rejected the unlawful means. Or have I misunderstood that?
Well, I'm just looking, it's page 265. I think he actually comes straight at 272. In respect to the period prior to the settlement agreement, paragraph 170, reasonably arguable in the sense it's not fanciful to allege all the defendants except Mr. Knight conspired by the interest of Bonham, US affiliate, by auctioning the 10 cars at Quell Lodge in a manner that was not to the best advantage of MRL and involved a deliberate breach of Bonham and Butterfield's fiduciary duty. Though the case that Lohomij and Mr. Lumen were involved in such conspiracy is only barely arguable. That's the full extent of the allegation of unlawful means conspiracy. I should have thought had a realistic prospect of success, were it not for the settlement agreement. So that's what he said should go forward. I've made my submissions about fiduciary duty and unlawful means, and I'm not going to repeat them.
Yeah.
So we now go to the point on limitation, which I wanted to pick up at paragraph 150, page 263, and it's referring to the conduct of the auction, deliberate breach of fiduciary duty, holding the auction in the UK, failing to allow sufficient time, refusing to allow MRL to proceed with the sale. These are the various items which are complained of. It says the claim against Bonhams lacks reasonable grounds, has no real prospect of success, because it was Bonhams, not Bonhams and Butterfield, that conducted the auction. Well, with respect, there are 2 points there. The first is that if there was a conspiracy, then Bonhams, as a co-conspirator, are liable in respect of it. Secondly, that Mr. Brooks was a director of Bonhams and had been responsible throughout in his capacity as director of Bonhams, and therefore Bonhams were vicariously liable for Mr. Brooks. So to say that the claim against Bonhams has no real prospect of success is, in my submission, not open to the judge. But he then deals with Mr. Brooks, lacks reasonable grounds, not alleged he owed personally fiduciary duties. No, claim is that he was a conspirator in the unlawful conspiracy. Then we get to Bonhams and Butterfield. Contracted with MRL, the short point is the claim is barred by limitation of time. And we have either a 4-year limitation period or the delayed discovery principle, which is effectively the same as R14A, and then there's the fraudulent concealment principle at 1533, which is effectively the same as R section 32, and there was expert evidence to that effect. Now, he says at 4, there's no realistic prospect MRL will be able to avail itself of either the delayed discovery principle or the fraudulent concealment principle of the particulars some of them were mentioned in the spring law letter. Particular 5 was necessarily known to MRL. Particular 8 regarding the payment plan, received in November 2014, and 11 were necessarily known. And then there was the proposed amendment, breach of the commercial agreement by offering the payment plan. Although the particular claim relies on various matters set out, as elements in the tort of unlawful means conspiracy, paragraph 122 states that MRL relies on them also as freestanding causes of action. When the freestanding causes of action are particularized, a new allegation is not repeated, although the allegation of Bonham's breach of commercial agreement set out paragraph 130. 131 accepts it can't be relied on as a freestanding cause of action because it's settled. Not a freestanding cause of action. So what he is concluding here is that the conspiracy claim, which, if it is not settled by the settlement agreement, is manifestly statute barred. But it's not, because the conspiracy claim against Bonhams and Butterfield is pleaded against them, is a claim in which we say we had no knowledge until November 2017 when Mr. McLean told us. And for the court to conclude that we knew of the conspiracy before 2000, within the limitation period, and cannot extend it, is simply making a wrongful assertion. Until we know the other elements in 2017, our claim against Bonhams and Butterfield is not statute barred. Now, I accept that I need my plea in conspiracy to survive, and that depends upon the settlement agreement. But if the settlement agreement does not bar a claim in conspiracy, then the claim against Bonhams and Butterfield cannot be said to be statute barred. Lady, the last point I want to come to is my ground 6, which, as I indicated at the outset, I propose to take at a relatively high level. I accept that this court cannot go through all the findings made by the judge on each of the items where he accepted the contentions of the defendants should be upset on, so to speak, on a one-by-one basis. My point in relation to that is that where there is an allegation of conspiracy said to have begun before and continued after the settlement, where the only basis on which we are not allowed to run that conspiracy argument is because it is said that it was settled by the settlement agreement, the judge should have approached our allegations in respect of the period after the settlement agreement on the basis that he should only strike them out if they were plainly and obviously never going to succeed, irrespective of whatever emerged on disclosure and irrespective of the evidence that would emerge at trial. And we say that the judge fell into error in conducting what was effectively a mini-trial, pages and pages of it, days and days of argument on specific points, when he only had a quarter of the story. If that, he didn't have the disclosure on both sides, he didn't have the witness statements for trial, and he didn't have that most crucial element of any trial, which is the cross-examination of the witnesses, where so much emerges. And I can give you just one example. I've given you already the example of the preferring of his view of the documents to the evidence of Mr. Walmsley. I'm not going to repeat that, but I'm going to give, if I may, in addition to the matters which are set out in skeleton argument. One further example. If you could go, please, to the judgment at page 306. Sorry, I beg your pardon. It's 325. I muddled up pages with paragraphs. Very mindful. He begins his discussion on the post-settlement agreement at 302, and that he makes a number of points. At 306 third, I'm entirely satisfied. Revised case is factually incorrect because Mr. Schlumpf was not at the meeting on the 6th of July 2016. On this point, there is a conflict between the evidence of Mr. Sullivan and Mr. Hilda, who say, and that's in their witness statements, the strikeout, that he was present, and that of Mr. McClellan and Ms. Volk, who say that he was not. But MRL's case on this point has been inconsistent to the extent it appears to be finding a way to salvage an original and untenable case, and the document showed the position clearly enough. On the morning after the meeting, Mr. McLean's email to Mr. Luhmann, copied to Mr. Schlumpf, identified those present at the meeting. They did not include Mr. Schlumpf. So one piece of evidence, the note doesn't include it. Further, Mr. Schlumpf had not intended to be at the meeting, as shown by an email he sent to Mr. McLean on Thursday, 30th June, expressing best wishes. Therefore, if Mr. Schlumpf and Mr. McLean said what they are alleged to have said at the same meeting, that must have been the same meeting on the 2nd of June. That's consistent with the particular claim, inconsistent both with Mr. Sullivan's evidence and the reply, and with the case being advanced. Sale 1 fell apart in the aftermath. There's no evidence from Mr. Schlumpf. There is evidence from my client that they were at the meeting. The fact that the emails didn't mention he'd been there is a matter for cross-examination. But you can't dismiss statements made by my client simply on the basis, at summary judgment, that he's not included in the attendance list. And that's one of many examples of the judge doing what he was urged to do by the defendants, namely looking at statements, looking at documents, and reaching a conclusion as to what happened, which is a matter for trial, not a matter for this kind of strikeout summary judgment, where the court must proceed on the assumption that the claimant's case is correct, except where it can be shown clearly not to be correct. And the absence of a name on the list of people attending is simply not good enough. And it's repeated time and time again. And we say that that, together with his mistakes in relation to the first part, vitiate the judge's findings, and that if you are with me and conclude that my claims in conspiracy, etc., are not barred by the settlement agreement, this part also should go to trial. I need to deal with the question of implied terms. Can we turn, please, to my skeleton, tab page 58 of bundle 1, page 23 and 25. Pick it up here because it's useful. The judge commented only in passing on our evidence relating to the sales. And he did. He didn't look at it. Indeed, he didn't need to, because he was not deciding the case. He quoted the email from Mr. Sullivan, and the court can read that. And everybody's being told that they'll be able to buy the cars direct from Mr. Lohomij for the outstanding loan amount. So not surprisingly, the bids weren't coming in very fast. This, of course, is totally unacceptable. On a natural reading, this email asserted Mr. Sullivan's complaint on behalf of MRO, Lohomij, and Mr. Lohomij's conduct. But all the judge said is it might be noted this email does not actually accuse Lohomij, Mr. Trump, or Mr. Lohomij of having done anything to interfere with the proposed transaction. Appears to assume they would not do so. Well, just standing back from that, we have a suggestion that they're telling everybody that you'll be able to get them at the value of the outstanding loan by the end of the month. And to say that that is not a complaint and that is not an act interfering with our ability freely to sell the cars at their best price simply can't be right, and wholly fails to give proper weight and prominence to our evidence. And then we deal with the duty not to prevent or interfere with the disposition. 89, clause 9 prohibits them from unreasonably withholding their consent for the disposal of the cars. So they can't unreasonably withhold consent. It cannot be said in my submission that you can't unreasonably withhold your consent, but you can do anything you like in order to prevent an offer being made, so that you are able to repossess the cars at the end of the extended facility period and make a profit on them yourself. And in my submission, it is perfectly open to the court to conclude that that duty under clause 9 carried with it an implied term that you should not take any steps to interfere with the sale process prior to the moment of consent being sought and obtained. And I've set it out in detail in the skeleton, and I'm not going to take any more time with it. So, my lady, my lord, in conclusion, what we say is that the judge approached the question of the settlement agreement and the sharp practice rule in the wrong way. He assumed that the spring law letter amounted to awareness of sufficient acceptance of the risk of a conspiracy so that it's caught up in the settlement agreement. And throughout, he fortified his conclusion on that by making findings, by conducting a mini-trial before and afterwards. And for those reasons, we invite you to allow the appeal. And unless I can assist you further, I think I'm within my time.
Thank you. Lord Justice Arnold, any questions?
No, thank you.
Thank you. Thank you very much, Mr. Fenno. Mr. Cledhill. I wonder whether you want to begin or whether we should take our 10-minute break now, let you begin at 3.
Completely in your hands.
I think that would be, despite the fact it comes earlier in the afternoon for the transcript writers, I think that would be more sensible, so we should begin at 3. Thank you.
That's fine.